Good morning. I'm Gloria Jean Sweetlove, and I'm President and Director of the National Association for the Advancement of Colored People in the state of Tennessee. And we have convened this workers' conference to discuss workplace issues not only across Tennessee but across the nation. If our workers are not treated fairly, if they don't get the right benefits, if labor laws are not enforced the way they need to, this country will lose its greatest asset. So we brought together a cohort of labor supporters really from across the state and across the nation today to discuss workplace justice.
Hello, my name is Jill Atkins. I'm with the National Labor Relations Board here in Nashville. I was invited here by Cheryl Allen, and I want to do a shout out to her and say I appreciate it very much. The law that I help enforce is the law that gives you the right to discuss your wages, hours, and working conditions with your coworkers in your work environment. The National Labor Relations Board also handles problems and situations between unions and companies. But for those of you that are not a part of a union, you still have rights under the National Labor Relations Act. Anytime two or more of you get together to help improve your wages, your hours, or your working conditions, you are covered by our act. And of course, unions are also covered, and we handle them with regard to the collective bargaining agreements or their attempts to organize a work environment. No matter what, you have rights. Don't forget that, and don't ever give up.
All right, so we have a fantastic panelist of professionals across a wide scope of labor issues. I just want to, I read a little bit about your bios to the audience, and so we're just going to start with a question. You all can share the mic. The goal today is to help people learn more about their rights. And so the first question I want to pose to the panel is, name one myth in your scope of work that you try to break through every day to the public, that people may have been misinformed or miseducated about, that you think is a top myth that people have about what they can do if they feel that they've had a challenge at work and they need to take action. So why don't we start with you, Jill?
Is this working?
Yes.
Okay. The top myth that I like to debunk is that you have probably found in handbooks throughout your work environment a policy that says you cannot discuss your wages. How many people have seen in a handbook in their lifetime a policy that says you cannot discuss your wages? That is unlawful, and it is in writing. And the National Labor Relations Act supports your right to discuss your wages with your coworkers in order to determine what they're making, what you're making, what you can do to make more money, and also if perhaps you're being discriminated against in your pay. If you run across a handbook anywhere that says you cannot discuss your wages, I want you to call me. My number is 629-800-6272. That's 629-800-6272. That is an oppressive rule, and you do have the right to discuss that, so that is the number one myth. If you run across it, it is not legal.
One of the things that the EEOC we find is that people are told that they have to do certain things with their employer when they want to report discrimination. Okay, they tell you that you have to go to your supervisor or the next person up or human resources. That's not always true, okay? Because if your supervisor is the one that is discriminating against you,
Right.
You can go to the human resources, or you can come directly to the EEOC or the Tennessee Human Rights Commission. And if your employer has less than 15 employees, we will direct you to the Tennessee Human Resource Commission, Human Rights Commission, I'm sorry. And if they have more than 15, then they can come to us. if you have a disability, please come to the EEOC, because the Tennessee Human Rights Commission does not have jurisdiction over that. Okay, or if you need any kind of accommodation as far as religion, also come to the EEOC, because that is our jurisdiction. And even if you have questions, you know, you can always come and talk to us. You can call us. You can go on our website at eeoc.gov. We have a wealth of information on the different laws that we cover.
From a legislative standpoint, I would say the top myth is that my vote doesn't count. And I know that NAACP, we got an audience of activists, and I hope each of you all are voting for every single election. On local election and state elections are where we're losing more ground probably than anywhere. I know on the national front, we see our current president kind of rolling back a lot of really progressive laws that help working class people and women in particular. But I want to assure you it's on the state level and the local level where we're really losing ground. So every single election, especially state elections and local elections, I want to encourage you to go out and to vote. And to not only go out and to vote, but to take at least 2 more people with you to vote. And then coming down there at the state capitol, you've got to show up. You got to show up. And believe me, I hear people say, oh, it doesn't make any difference. It really makes a difference when you show up. When there's contentious legislation down there and you show up in those committee meetings, I've seen the tide change. Right. So that would be the biggest myth, is your vote doesn't count and your presence doesn't count. But I assure you, with just a few people, you can turn the tide and affect how a vote goes.
So I think the biggest myth for us, and I was talking earlier with some ladies, is that our name, Tennessee Human Rights Commission, covers all human rights issues. Our purview really is in employment, housing, and public accommodations on all the protected classes. And we do cover disability, just not if it's disability accommodation. So if you're asking for an accommodation in the workplace, we do transfer that. But if it's just dealing with, because of your disability, you're not being promoted, then we can deal with that.
A big myth that I run into a lot is that if you are wronged on the job, then you should be compensated. And so clients come into my office and they're spending a lot of time or trying to try to verbally convince me of their wrong. The reality is that you need proof.
That's right.
You need to gather some sort of proof of how you're wrong, whether that proof be in some kind of written documentation, whether it be in the form of videotape, audio tape, which we might be able to get into later. And then lastly, many times folks are a little cowardice, folks who you think are down with you, and at some point in a litigation standpoint, you're going to need other folks to acknowledge that the thing that happened to you happened to you. Right. And a lot of people lose at that point because they can't get other people who talked about what a travesty it was to even do an affidavit on their behalf. So that's a big myth that I run into a lot.
Okay, great, thank you. So that's a great segue into the next question, which is, what are some suggestions that you would have to employees to even recognize that something illegal has happened to them? What's the standard by which a person can say, okay, the actions that my employer has taken now are wrong? So let me give you an example. Let's say around pay. If they are denied a raise, or if they've applied for a promotion and been overlooked. Oftentimes, maybe they didn't get that job for reasons such as experience or education, but I think you all get a lot of calls, a lot of questions about, this happened to me, is it fair? What are some of the 2 or 3 things that employees need to understand that would create the standard of this is wrong and they need to take a next step? Is it true, do you think, that people may not always recognize that something's inappropriate that's happening in terms of the way they've been treated? And talk about how people can become more aware of what's happening on the workplace.
So there's a concept of disparate treatment, a concept of the extent to which, and I think a lot of people have a gut feeling that something is going on that's wrong. So for instance, in the area of racial discrimination, the extent to which as a black person you see, well, I did this, I was treated this way, but Sally, who's not black, was treated in a better way. I mean, that's something that if you recognize, that might be something that you want to consult with a lawyer or with the EEOC or Tennessee Office of Human Rights to kind of get an idea of if anyone who has credentials in that area agrees with you that there is discrimination. The same type of thing with workers' compensation, to the extent that you might not know the law. If you get injured at work and you're told, which often happens, that they're not going to go the workers' comp route, but they send you instead to do it under your health insurance, then again, that's something that you might want to consult with the Department of Labor or a private lawyer about that matter. So I would say when things come up like this and you kind of get an idea that doesn't seem right, you want to consult with an expert, either with a governmental agency or privately, outside of your workplace, to see if they can confirm that and they can let you know which steps to take after that.
Great, thank you. Any other responses?
The biggest thing is you want to know what the policies say in your workplaces. And what I often tell people is when you get hired, I mean, it's like you're buying a house. You get paperwork thrown at you and everything's coming at you at once, and you're just happy to have a job and you're just signing things and you haven't read one word. And then if something happens, that's the first thing that they send to us. See, they signed the policy, and the policy says that I hereby have read and understand, right? But you haven't opened that book since the day you got into the job. So what I recommend is that all employees should read their policies refresh every time. And then if something happens, you'll know if they're applying that policy across the board, or if they didn't affect me, or like in your example, they let Sally, take off time and it's not in the policy. And when I asked to take off time, they said no, that kind of thing. So then you'll be able to know what is different and what is not.
But if an employee has a question relative to something that's in their policy, could they then contact you all to say, okay, for some clarification? Because now we know it's not written in terms that the average worker will understand anyway. So could you guys, would you be available, are you available to clarify some of the nomenclature that's written in policies and handbooks?
What we would look for is how they're applying that policy. So we would say, okay, when did you use this policy? How did you apply it? What situations were with it? What were the people? What was their makeup that you used the policy on? So those would be the questions that we would ask you. So you think they violated this policy? Well, who did you see use this policy? What was their race? What was their, whatever protected class you're looking at. So we're not going to interpret that policy for you, but we're going to say, did they apply it across the board, regardless of the protected class?
No.
Somebody said no.
Okay, and I would also suggest that an individual use every resource at hand, and I hope everyone's in the audience is a paying member of the NAACP. But the NAACP is still very relevant. I hear that sometimes about NAACP not being relevant, but believe me, sometimes when you just shine the spotlight on these situations, I have seen some incidents where employers will pull back and will raise up off of employees that they have just kind of been needling and harassing. So, and in fact, I refer sometimes individuals to the NAACP and the legal redress committee. So I would say to use every resource at hand. Even as elected official, I've gone with some employers to their hearings, to their appeal process. So any resource you can use in terms of your elected officials, your metro council person or alderman or commissioner in some of the rural counties, and the NAACP, use those resources as well.
And let me add to what Representative has said. She's exactly right. It's important that you're a member, because as NAACP officers, we are qualified to go with you to EEOC hearings, mediation hearings, and etc. We are qualified to go as your advocate. So, that's why I try to get us to this kind of stuff, so we'll understand what it's all about. But you can go, and when you show up, I remember I showed up in Memphis with an employee, the HR manager like to jump out of his seat.
Things change when we're at the table.
Oh, they definitely do change. Just you showing up does make a difference. So.
We're gonna let the panelists finish this question, and then we'll take a couple of audience questions.
One of the things that I would recommend during our investigations, we always find that the evidence that the employees have is word of mouth.
I am Daniel Marshall. I am a lawyer here in Nashville, though I practice in about 5 different counties. Cheryl Allen told me about this event. She's with the NAACP, and my understanding is it's dealing with labor and employment laws. That's one of the areas that I cover, and I'm very concerned about some of the things that are happening to workers, and I'm certainly interested in folks being appropriately educated as to their rights and being able to fight against some of these evil multinational corporations, etc., which are intent upon violating their rights.
My question is, what is the difference in terms of employment law or whatever?
The EEOC looks at it as long as it is not, the adverse action is not occurred because of your protected status.
And I would just encourage, again, each employee to exhaust every avenue that they can.
Yeah, and I echo that. We do hear, we get complaining people calling us, but their thought is saying, well, nothing's going to happen anyway. You're not going to do anything. You can't do anything.
Sometimes they act better when they know you've been looking at them.
Let me add to that. For me, my definition is that with at will, absent having a contract with the employer,
And how's that different from corporations versus nonprofits? Is there any significant difference if it's a nonprofit, or is it treated the same?
There's no difference for us or the EEOC, but.
And then in terms of confidentiality, if we call your agency and you look, are they gonna know my name? Are they gonna identify me? Will my employer know? Or
There's no anonymous filing. So you have to step up, file, sign your name to a complaint. Now, any of the information that you send to us, your witnesses, people that we're gonna talk to, those will be confidential. And they also would have a right to file because they participated if something happened to them under the retaliation piece. So when you're talking to your witnesses, explain that piece to them. When we call witnesses, we explain that, because they're like, I'm not getting in this mess. And we hear that a lot, where you said, no, this person is going to tell you what happened, they were there. And then we call that person, and it's voluntary, we're not gonna subpoena them or anything to talk on your behalf, it's voluntary. But they're gonna say, I'm not gonna get into this because I don't wanna get fired. And so we explain to them the retaliation part, the protection that they would have for participating in the investigation. Should something happen to them, they have the right to file.
does it have to be someone that's currently working there, or what if it's
No.
someone that left the company already because
No.
something happened to them?
We had a situation where we do, because we worked across the state, a lot of our interviews are by the phone for budgetary reasons. We can't go out everywhere. But if it's with a manager, we have to have, and they're represented, we have to go through the job to get to that manager. And we had an investigator who was talking to them, and she could just tell that, you know, there was, like, say this, right?
Yeah.
So,
Yeah.
right? So we had that. So she told me about it, and we kind of were like, well, we can only deal with what we can get. But later on, the lady called us back without the representative and provided us information and said they were writing down things for me to say. You need to ask about this, right? So our investigator went back and asked about the certain thing, and then they fired her. So she was able to file with us on retaliation.
More audience questions? Oh, I'm sorry, one more response from Jill, I'm sorry.
So the first question about at will, I think it's important to understand what the depth of at will means. The quick answer is at will means they can fire you for a good reason, a bad reason, no reason.
Right.
But they cannot fire you for an illegal reason, okay? That's a subtleness right there. And there are precious few illegal reasons out there. There are a lot of bad reasons, there are a lot of good reasons, and there are no reasons. To understand what the precious jewel you have in this panel, in the EEOC and the NLRB, is that there are precious few things that are actually illegal. You cannot discriminate or terminate or write somebody up because of their age, race, sex, national origin, disability, religious belief, union or anti-union affiliation. And my agency handles the latter too. It doesn't matter. So a lot of employees call up and say, well, it's at will, they can do whatever they want. No, an employer cannot do whatever they want, okay? But what little rights you have, they're being chipped away at. Fight for them. The other question, nonprofit profit. From the NLRB standpoint, it doesn't matter. As long as they're not like a state agency. Now, we're federal, okay? So we don't assert jurisdiction over the Tennessee Valley Authority or state employees. And the other question, the confidentiality issue. I have a big issue with confidentiality in handbooks. Not being able to talk about your wages is a confidentiality policy. When I get a handbook, I'll look through that handbook and I'll look at the confidentiality policy. If it is too broad, meaning you can't talk about anything, that means you can't talk about your wages, you can't talk about working conditions, you can't talk about your write-ups. Why do you have the right to talk about a write-up? Because Uncle Sam doesn't want you to get fired.
Believe it or not, Uncle Sam does not want you to get fired, because what happens when you get fired? You can't pay taxes. Okay? So think this through. If I don't know what's going to get me terminated, if I don't know what's going to get me written up, then how can I avoid getting fired? I don't want you to get fired. And if you don't know what, is it Alice or? No, I was like, here.
Sally.
Sally. We're going to just go with Sally. Sally's a very interesting person. If you don't know what Sally did to get fired, then how do you know to avoid doing what Sally did? It doesn't make a lot of sense. Now, the only times like we look at confidentiality, the only times that we think, okay, it's okay. You can have that confidentiality. If it's going to result, if disclosing this is going to result in destruction of evidence, okay, then we'll say, okay, like in drug cases where maybe somebody's dealing drugs on the plant floor, well, okay, you can have a confidentiality policy while the investigation is going on, but it has to have an endpoint, okay? You can't have a blanket, this is forever and a day until the Lord comes back, confidential. No, it's got to have an endpoint.
I want to chime in and add something on the confidentiality. At the EEOC, we usually draft the charges for the charging parties because we don't want to have a rambling complaint. We want to make it concise and not give the employer all our allegations and evidence. Okay, but we keep the charging party will when they sign that form, then we will send that form to the employer and to have them respond to that. Now, and people calling up and asking us about a charge, if you're not that charging party or the respondent, we ain't gonna tell you anything. Okay, so, and unless we have letter representation, okay? And one of the things also that to keep in mind with regards to retaliation, once we serve that charge and they take an adverse employment action against you after we've served that charge, then that's a possibility of retaliation. Okay, and even if you complain internally and use your internal process, and they take a adverse action, well, we can also look into that as retaliation. An adverse action, if you're fired, discipline written up, laid off, anything bad that happens to you.
What about if they reduce your responsibilities at work or anything like that? Is that an adverse action? If they say, well, we're gonna put you in a different job?
Right, a lot of times they'll put you in a different job, lower pay, or they'll say you have the same title, but you get everybody else's work. Anything pretty much that you think is a bad action could be what we consider an adverse action.
Okay, so I'd like to kind of echo what's been said. There's no perfect employee out there, okay? So if you did something like you were late, from break, please tell us. Because if you don't tell us, it'll be the first thing out of the employer's mouth. But understand this, that there really is no perfect employee. I'm not a perfect employee. And so anytime an employer feels like finding dirt on you, it's not that hard, okay? Because we all have dirt. That's okay. You just need to understand good documentation. Well, is everybody late from work? I've got a case where somebody was written up for smoking. Well, he's telling me everybody was out there smoking. Right. Well, that's relevant, and that's relevant evidence. Sexual relations in the work environment, we really don't deal a lot with that at the NLRB. It's from our perspective, if it's consensual, we're not getting involved, We do refer people to the EEOC on that. I don't know, it's the work environment. Lots of people hook up, you know. Lots of people have met their spouses. So, you know, we do keep that in mind. Seniority. We do a lot with seniority and collective bargaining agreements. But in Tennessee, and again, we deal with non-union environments too, as long as 2 or more employees get together to improve their wages, hours, and working conditions. That's a union in the eyes of the NLRB. Okay, it's more of a casual union, but it's still a union. Okay, a lot of employers say, "Oh, I don't have to worry about the NLRB. We're not union." Oh yeah, you are. You're union every lunch, break time, smoke time. You're union because your employees got together and sat down and talked about work, and
What if
that was us.
What if you get fired for that or get in trouble for trying to start a union?
Okay, that means you're the troublemaker, right? Okay. I love them. I love the troublemakers. Thank you for, I'd say, be loud, stand up, don't be silent. Because that's exercising your right to discuss your wages, hours, and working conditions. And if you are written up for that, terminated for that, being the leader of that, whatever, that is a union. You got together with 2 more employees, and the troublemaker, the person that spoke up, they were the informal local union president. And you can, if you're terminated for that, written up for that, you're isolated. You know what they do with the troublemakers? They isolate them. So a adverse action would be where you spoke up for, you know, yourself and others, has to be others, and then all of a sudden they reassign you to a job way out there in backfield. There you are, way out there. They're isolating you. That is an adverse action with us and with the EEOC, so we might cover the same thing.
That's great.
Can I add something to that?
Sure.
Again, I wanted to reiterate, even if it's not illegal, if there's an action that's not illegal, if it's adverse to your employees or people that you know or your relatives, again, have them to exercise every resource that they can. Call their council person, call their alderman, commissioner, state representative, state senator, NAACP. I assure you, in most instances, now there are some people that are so bold and crazy, no matter what you do, it's not going to help unless you sue them. But in most instances, when they get a piece of paper with a stationery, with an agency as powerful as the NAACP or the state representative or the state senator, they are going to stand down. When they get a letter saying, my constituent says that in your environment, your daughter is your administrative assistant and preferential treatment is being shown toward her, in most instances, they're going to alter their behavior. So again, even if it's not illegal, again, exercise and use every resource you can to make sure it's an even playing field for everyone.
All right.
So,
Okay, we got 3 more questions? Okay. Go ahead.
because I heard something, does the law not apply to state employees the same as it does to privatization and nonprofits? I heard that from one of y'all.
The EEOC will investigate state employees.
Tennessee Human Rights doesn't, the EEOC does.
The EEOC does.
It was this young lady who said she didn't.
The NLRB does not do state agencies.
You
Okay,
don't.
that's okay.
And see, my other question would be my second one, because I've heard 3, and I found myself to articulate well, but the average Joe Blow, Sally, or Sue, well, how do we know this? Because the myth within especially in the poor communities and on these warehouse jobs, they like, man, I got fired, I'm going to EEOC. But that ain't what I heard today. I heard you in the orange, and I heard you say, come to me.
Here's the thing, go to anyone.
Okay, okay.
Let's
And so,
Right.
and
The
how,
EEOC and the Tennessee.
and how do we consolidate some information like this as such? Because everybody ain't gonna come to a forum like this. And are you saying that it's left up to us, Madam President, to get it to this committee?
You got
here?
to- you
'Cause
gotta
this,
get it
this,
out to the
this,
committee.
this really stirred me, because I always thought, and I got a college degree, that you're supposed to go to EEOC. And that ain't true.
What you saying? If you go to Tennessee Human Rights and they don't handle it, they gonna send you to EEOC.
We're gonna-
If one of them don't handle it, they gonna send you to the
Right.
other.
And you can come to any of us. If we can't handle, we have a relationship with the EEOC. So if it comes in our venue and it's something that we can't cover, which is like disability accommodations is one that's key, then we're gonna process that for you. We're gonna take in all of your information and we're gonna transfer it to them.
I'm telling you that if it's anything that your takeaway would be today is don't be silent.
Right.
If you ask somebody, any agent is gonna say, we don't handle this, but try X agency, try
Yeah.
XYZ agency. And again, use every resource. Don't get frustrated because when I was a young girl, my mother was trying to buy a house. She had never been a homeowner before. And she said, Brenda, I think it's a conspiracy. And I said, no, Mother, it's not a conspiracy. But as I get older, I'm probably getting a little bit more jilted. But the system is meant to prevent you from attaining your goals. So when you get a no answer, you just go next door and knock on that door. You can't give up. You just got to keep on.
In closing, I want to say I'm very honored to have been invited here. Thank you so much. And shout out to Cheryl for never forgetting about me.
This isn't intimidating at all, being up here. So I am Monet Brown. I am her daughter. I think that's why she chose that scripture. And I have been charged with giving a message for our young workers, for the millennials that are in the workplace. And so, yeah, that was my target audience. I'm sad we don't have more young people here today, but hopefully this is some information that you will share with them. These are things that I definitely wish I would have known entering the workplace. And so it was Martin Luther King Jr. that said, "Nothing in the world is more dangerous than sincere ignorance and conscientious stupidity." Well, for the few minutes that I have the floor, I'm going to talk about how when I entered the workplace, I entered with sincere ignorance. Growing up in a union household, I learned a lot about labor laws and workplace etiquette before entering the workforce. I was forced to go to union meetings and picket lines. I remember my mom nervously waiting each and every time as the hour neared for a new contract to be signed between her union and a place of employment. The moments that she would casually say to me, "We might be going on strike if they don't sign the contract." I remember being told at a very young age what a scab was, and that nobody likes a scab. So I knew a scab is something I would never be, and I'm sure this room is aware, but a scab is a person that continues to work despite all the other workers being on strike. The person who tries to keep the company from bleeding out from the wound of a strike. A scab. A scab was bad. But probably the most important thing that I was told was that Tennessee was a right-to-work state. And without that union and that contract, employees could be fired at will from the place of their employment. At 18, armed with all this knowledge I thought I had, I entered the workplace. Sincere ignorance is a dangerous thing, because the first thing I noticed when entering the workplace is that the majority of employees do not have the protection of a union. In fact, as of 2013, only 11% of the entire United States workforce was affiliated with the union. So my first job was with the nonprofit organization. There was no union there to protect my rights as a worker. I had no union rep. So I basically entered in the workforce ignorant, believing that my rights were the same as my mom's union rights at her workplace. Sincere ignorance is a dangerous thing. But over the years, and after many different jobs, I have grown a list of things that I wish I knew as a young person entering into the workforce. So I'm going to share these 3 things, and knowing that I am the one thing keeping you guys from lunch, it will be very short. The first thing that I wish I would have known is my rights as an employee. Not just every young person in the workplace. Learn your rights, know your rights, demand your rights. Thank you.
Awesome. Give our panelists a hand. Thank you all so much.